What's new at the Appellate Division? Stay tuned for this month's Legal Scoop. So this month we're dealing with a case from April of 2026, and it's called Davis v. Giaquinto Masonry. And it's an occupational disease claim for both hands, both wrists, and both knees. And the issue was whether the doctor, the claimant's doctor, met his burden of proof on causal relationship. So the facts of this case were that the claimant went to see Dr. Hesht in September of 2022, and he stated that he worked for 25 years as a brick mason, working 35 to 40 hours a week. He reported that his job duties required repetitive lifting, carrying heavy boxes, bending, squatting, troweling, hammering, climbing ladders, and scaffolding, and using vibrating power tools, chipping guns, and wet saws. And the board established this claim for an occupational disease, finding that Dr. Hesht did have sufficient knowledge of the claimant's job duties and how much time he spent performing these job duties. And if you watch this series, you're probably pretty well aware of the case law that applies here, which is Matter of Padawan v. PAL Environmental. And that case states that in occupational disease claims, the doctor needs a very sufficient understanding of the claimant's job and job duties, how long they spent performing those job duties, and then the doctor needs to actually link that knowledge to the occupational disease that's being diagnosed. So what did the court ultimately decide? It actually affirmed the establishment of this occupational disease claim because they said that Dr. Hesht was aware of the claimant's specific repetitive job duties and the length of time that he practiced these job duties. But I think what we would like to see from the court here is more detail explaining the level of knowledge that Dr. Hesht had. If they're going to require that the doctors demonstrate a very specific and broad understanding of the claimant's job duties, how long they did it, and how it led to an occupational disease or occupational diseases, their decision should also, in detail, state what the doctor relied upon. But they didn't do that here. So it leaves some questions of, how specific was Dr. Hesht really? There's some mention of the claimant's testimony about how many bricks he would lay per day. Did the doctor know that? The case doesn't say. So again, what does this mean for your cases? Well, pretty much you almost always are going to want to controvert occupational disease claims because the burden of proof is pretty substantial. So anytime, unless the doctor really goes through the claimant's job duties in detail and that detail is accurate after you interview an employee of your insured or your company, it's worth considering a C7 for any occupational disease claim and referring it to defense counsel to at least consider the possibility of it.